Thank you very much. I wanted to extend a welcome and a good morning to all who are attending and those who are watching remotely. This is a meeting of the New York State Unemployment Insurance Appeal Board. This is our first meeting of 2023, and I'm located today in the board's headquarters in Menands, New York. I hope all attending and watching and all your families have had a happy new year and are enjoying good health and will continue to do so. My name is Geraldine Riley, and I'm the chair of the New York State Unemployment Insurance Appeal Board. The draft agenda has been published, and the minutes from the previous July 20th, 2022 meeting have been circulated to the members, and the public has been invited to observe in real time. This meeting is being recorded and will be available along with the minutes on our website, uiappeals.ny.gov. I would like to begin this meeting by expressing my thanks to all of those who have supported the work of the board and in addressing the many tasks that we face. I would like to thank the staff and the leadership of all of our offices, and of course, and primarily, I'd like to thank my colleagues on the board for their work, encouragement, and support. For this first meeting, I would also like to acknowledge the myriad innovations which this year will bring. You will hear more about these exciting projects during the executive presentations, but I can assure you that 2023 will be a year of technological innovation, which will change many aspects of how we do our work, all in the interest of serving our customers and our employees in a smarter and a better way. Again, it is my hope that this consistent schedule of board meetings presents a board that is proactive and accessible, and a board which aggressively addresses the 21st century challenges that we face or that we anticipate, and that we address those tasks with optimism and confidence in the skill and effort of our many talented employees. Each board member and each staff member is serious and interested, industrious and engaged in their approach to the important work that we do. I sincerely thank them for that. I want to acknowledge and thank our Chief Administrative Law Judge, Tracy Covey, who is based in Syracuse and who has worked tirelessly to advance the board and our mission. Tracy has assumed this role in a time of pandemic crisis and has led the board judiciously since. And I wish to thank Principal ALJ for Appeals, Christopher Tate, who is with me today in Menands, for his work in these very trying times. I want to thank Melissa Souza, who is taking minutes, and Caitlin Smith and Amy Higbee, who will be assisting with their technology today. I would like to provide an overview of our agenda today. All members present in locations accessible to the general public will be asked to vote on proposed resolution 2022-01 regarding UIAB compliance with the open meeting law to allow remote participation of board members in certain circumstances. This resolution has been posted to our website and distributed to our members. After the resolution passes, any remote members may then join the meeting after a new roll call recording their attendance of the new voting quorum. Before the call to order, I would like to remind members, staff, and the public that our next public meeting of the board will be held Wednesday, April 19th, 2023. Thank you. I am now calling this meeting to order. Our first order of business is a roll call of attendees conducted by our Chief Administrative Law Judge, Tracy Covey.
Thank you, Chair Riley. I will first note your attendance in Menands and will take the remainder of the roll call. When I say your name, please indicate that you are present in a location that is accessible to the public. Board Member Marilyn O'Mara.
Present in Menands.
Board Member Michael Greason.
Present in Brooklyn.
Board Member Randall Douglas.
Present, Plattsburgh, New York.
Chair Riley, you have a quorum.
Thank you, Tracy. A quorum being present, our next order of business is to read and adopt the proposed resolution 2022-01.
Madam Chair,
questions?
I'm sorry.
I was going to ask
Madam
whether
Chair,
there are questions or concerns. Go ahead, Michael.
Madam Chair, I move that we waive the reading of the proposed resolution and adopt it into the record as presented.
Is there a second?
I'll second that.
Thank you, Randy. A motion being put forward concerning the adoption of the resolution. All in favor, please indicate by saying aye.
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 Any in opposition? Hearing no opposition, the resolution has been adopted. Thank you. We now move on to the next order of business, which is an additional roll call, which will be conducted again by Chief Administrative Law Judge Tracy Covey.
In addition to the board members who have already indicated they are present, Board Member June O'Neill.
Present. Thank you. Thank you, June. Thank you, Tracy. We now have a quorum of all members, remote and present in locations that are accessible. So thank you very much. Thank you for everybody for your help with that. We'll now move to the regular order of business, which is to review and adopt our agenda. If the members could please take a moment to review the agenda, and if you have any questions or concerns, please let me know. Is there a motion to accept the agenda?
So moved.
Thank you, Marilyn. Is there a second?
Second.
Second. The motion being moved and seconded, all in favor of adopting the agenda, please indicate by saying aye.
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 Thank you. Is there anyone in opposition? Hearing no opposition, the agenda has been adopted, and we can move the next order of business, which is the reading and adoption of the minutes from our July 20th, 2022 meeting. Is there a motion?
Madam Chair, I move that we waive the reading of the minutes and accept them into the record as presented.
Is there a second to that motion?
Second.
Thank you, Marilyn. All in favor of waiving the reading and adopting the minutes into the record, please indicate by saying aye.
Aye.
Aye. Aye. That motion has been accepted unanimously, and the minutes have been adopted. We'll now move to the next order of business, which is the Chief Administrative Law Judge's report, presented by Tracy Covey. Tracy?
Good morning, everyone, and Happy New Year. I will be providing the Chief Judge report today, as well as the items generally reported on by the Executive Secretary. Under the able leadership of Chair Jerry Riley and the management team of the principal ALJs, including Chris Tate, Mark Sokolowski, and Justin Denton, as well as UIAB Manager Janet Bedoin, and our talented and judicial and administrative staff, we begin this new year with optimism and excitement. 2023 is a year in which many long-term technology projects will finally come to fruition, and we're very excited about that. First, our Unemployment Insurance System Improvement Modernization, or UISIM, has an anticipated go-live date of November 2023. Our subject matter experts, led by Kathy Gangware, continue to work diligently with the third-party vendor TCS, designing and testing our system. In the next few weeks, we hope to start seeing demos of the system's functionality. Our SMEs will also be engaged in train-the-trainer sessions with the vendor throughout the first half of this year. We also have an estimated completion date of a new IVR, which means Internet Voice Response telephone system, of next month. When implemented, the UIAB will then have one main number for people from the outside to call in. It will have an automated menu that interacts with callers and connects those callers with the appropriate staff person who can help them answer their question or address their issue. This should help us centralize operations, distribute work more efficiently statewide, and respond to calls more quickly. I am also very happy to report that we have begun work on a virtual hearing system. This is a real game changer, and it uses WebEx technology with a front-end application that schedules and allows individuals to participate in video conference unemployment insurance hearings. So instead of receiving a phone call, parties will be able to log into an online system and see our ALJs and the other parties during the hearing. The anticipated completion date for this project is June of 2023. We also recently finished the digitalization of our appeal board library decisions. All pre-2008 cases, which were only kept in paper format, have been scanned and converted to PDF files. These will be available through an internal archive later this year. In staffing news, our judicial and administrative staffing is presently at 111 employees. We lost several judicial staff to retirements and other agencies within the last year and are in the process of interviewing candidates for 8 open ALJ positions. 4 of those are located in Manans, 3 in Brooklyn, and 1 in Hauppauge. We hope to have the new class brought on board by March. We also anticipate posting additional ALJ positions in other offices in the upcoming months. We've also lost some administrative staff through attrition and continue to post and fill these positions as needed. Now moving to our statistics, unfortunately, despite our best efforts, we are still not in compliance with US DOL acceptable level of performance markers. On a positive note, our case age continues to decrease. The validated data as of November 2022 shows that the lower authority average case age was 31.23 days, which is very close to the 30-day acceptable level of performance. In December, it increased slightly to 33.6, but we anticipate that that will go back down. We are also still not meeting the compliance standards with 30 and 45-day time-lapse markers, but these numbers are also trending in the right direction. In the fourth quarter of 2022, approximately 20% of our cases were decided within 30 days and 64% were decided within 45 days. We are still out of compliance with the US DOL acceptable level of performance standards for the higher authority as well. But again, our case age is still decreasing. Validated data for November of 2022 shows that our average case age was 49.93, which is above the US DOL timeliness marker, but a decrease from the 51 days that had last been reported at the last board meeting. And in December, we had a bit of a blip on the radar where it went up to 55.09 days due to one significant old case, but that is also going to be rectified very quickly. The case age and overall inventory at the higher authority has been decreasing quickly due to all of your hard work and all of the decisions that you have been reviewing and signing. So thank you all. Turning to federal quality review results, I am proud to report that the third quarter of 2022, our average ALJ score was an amazing 99.15%, and that's out of 100. At this time, we are considered a large volume state, so 40 randomly selected cases are audited each quarter. All cases achieve the US DOL passing grade of 85 or better, easily surpassing the acceptable level of performance related to the quality of our work. None of the cases had any critical element failures, and 25 of the 40 hearings had a perfect score of 100. This is yet another continuing example of our judges' excellence in providing due process to the parties before them. This concludes my report. Thank you for allowing me to present this information to you today.
Thank you, Tracy. Are there any comments or concerns regarding this report?
Just a comment, Madam Chair. Tracy, thank you for everything you do. You are doing a tremendous job, and I really appreciate it. Thank you.
Randy.
Thanks, Randy. I know we would all second that. Tracy's
Yes.
been instrumental in so much of the success of the board. Just reviewing the average grade for the federal quality report is amazing, and it's a testament to the work you've done, and so proud to have been part of recognizing your talents and your leadership. And accomplishing this in such a short time is really a very, very significant accomplishment. So thank you for your work in this. So proud to see these reports, and I imagine that they will continue. So many thanks. Okay, is there a motion to accept the report of the Chief ALJ and incorporate it into the record?
So moved.
Thank you, Randy. Is there a second?
Second.
Thank you, June. All in favor, please signify by saying aye.
Aye.
Aye. Hearing no opposition, the report is incorporated. Thank you very much, and thanks very much, Tracy, for all the work you've done. Our next item on the agenda is the report of the Principal ALJ for Appeals, Christopher Tate, reporting on his work at the higher authority.
Thank you, Chair Riley. I would like to report on some significant cases that were decided by the court in the second half of 2022. A matter of McBride was decided on September 22nd, and the site is 208 Appellate Division 3rd, 1528. In this case, the court affirmed the board's decision that claimant voluntarily separated from her employment without a good cause. Claimant worked for a municipality as an assessor. Claimant's coworker yelled at her in response to claimant's request to postpone a meeting. Claimant resigned her position following the verbal altercation, filed a workplace violence form 3 days later. The court held that neither dissatisfaction with one's working conditions nor an inability to get along with one's supervisor or coworkers constitutes good cause for leaving one's employment. Citing matter of Gilliard at 170 Appellate Division 3rd, 1419, the court noted that claimant did not bring the incident to the attention of her supervisor prior to resigning, thereby both depriving the employer an opportunity to address the situation and failing to take steps to protect her employment. Matter of Chin was decided on December 15th, and the site is 2022 New York Aptiv Lexus 6988. The court affirmed the board's decision that claimant was ineligible to receive benefits because she was not totally unemployed, and charging her with a recoverable overpayment of federal pandemic-related benefits. Claimant was employed full-time by a municipality as a public safety officer. She was not required to report to work after March 21st of 2020 as a result of the COVID-19 pandemic. Although she did not return to work or otherwise provide any services for the employer until September 2nd, 2020, she received regular salary and benefits during the intervening period. In addition to her full-time employment, claimant was also employed part-time as a massage therapist and was laid off from that position in March 2020, and she filed a claim for benefits. The court noted that claimant remained on her full-time employer's payroll throughout the time that she was certifying for benefits, and that the board properly deemed her to be ineligible for such benefits on the ground that she was not totally unemployed, citing to matter of Robinson at 125 Appellate Division 3rd, 1038. The court also found that claimant was not eligible for federal pandemic assistance under the CARES Act, and that federal pandemic unemployment compensation, pandemic emergency unemployment compensation, and lost wage assistance benefits paid to claimant were properly recoverable. Matter of Gisser was also decided on December 15th, and that site is 2022 New York Aptiv Lexus 7021. The court affirmed the board's decision, holding that claimant, a tutor, was an employee of a company operating an online platform that provided tutoring services to clients. The court found that claimant submitted an application, resume, and a recording of a mock lesson to determine if she had the ability to adequately tutor. Claimant signed a separate written agreement outlining the minimum standards of professional conduct required. School districts communicated requests for tutors directly to the company. The company sent an email to all tutors allowing them to accept the session if they were available. If claimant accepted an assignment, she was required to notify the company at least 24 hours beforehand if she could not complete the assignment, and the company would provide a replacement. After accepting an assignment, claimant communicated with the school district to determine the needs of the student and a schedule, all through the company's portal. Claimant would then put together a lesson plan that fit the student's needs and conduct the lesson in accordance with the formatted model set forth by the company. After all sessions, claimant was to submit a report to the company detailing the student's progress. The company handled all the billing to the school districts and complaints received by the school districts. The claimant had no control over the pay rate or the frequency which she was paid, which was set by the company. The claimant would be paid if the student did not show, so long as she conducted a mini lesson that the claimant could access later. Citing matter of Patsis at 204 Appellate Division 3rd, 1278, the court found substantial evidence existed for the finding of an employment relationship. And the last case is a matter of Kaichuk, and that was also decided on December 15th, and the site is 2022 New York Active Lexus 7025. The court affirmed the board's decision holding the claimant was an employee of a subsidiary company of Amazon. The business operated a digital platform and a smartphone app that scheduled couriers to pick up and deliver packages and/or food orders of Amazon. They performed a check on claimant's criminal background, driving record, and insurance prior to hire. The company required couriers to install the app on their smartphone and provided them with instructions on how to use the app, which included GPS tracking with information as to couriers' locations, movements, and speed at which they were traveling. Couriers were required to perform all of their work in shifts broken into blocks of times, generally 2 to 4 hours, depending on what type of Amazon customer they chose to serve. The company set the fee that was paid for each block, which was listed on the app. Using the app, couriers chose the types of service they wanted to perform, as well as when and where they wanted to work each day by selecting one or more of the blocks posted by the company. Once selected, couriers could withdraw from working any block up to 45 minutes prior to the block start time without consequences. If couriers repeatedly canceled blocks within the 45-minute window, the company could terminate them. Couriers were required to deliver all assigned deliveries within the block of time and to follow delivery instructions on the app or reasonable instructions from the customer. Couriers were expected to use insulated bags when delivering food orders and check customer identification when delivering alcohol and collect signatures when instructed to do so on the app. They were also required to indicate on the app when they picked up a package and when they deliver it. The company found a replacement for couriers who canceled after selecting a block and paid couriers for their deliveries, even if Amazon did not collect payments from their clients or customers. Citing matter of Vega at 35 New York 3rd, 131, the court found that by providing the customers assigning the deliveries, limiting the time frame for the deliveries, and unilaterally setting the fees paid to the couriers, the company exercised sufficient control over significant aspects of claimant's work in order to establish an employment relationship. And Chair Riley, that concludes my report.
Thank you very much, Chris. Are there any comments or thoughts about the report from Principal ALJ Tate? I would like to thank Chris personally for all the work he has done and the excellence he's shown. And it's really become emblematic of the excellence in the higher authority, which defines in many ways the work of the board that we are so familiar with. And this selection of cases in particular, dealing with the employment relationship, really demonstrates that I think that the board is on the cutting edge of some of the most important employment issues of our time, and that we impact and that we deal with every day. So thanks very much, Chris, and your leadership in that area.
Thank you, Chair Riley.
Is there now I'd like to entertain a motion to accept the report and incorporate it into the record. Is there a motion?
So moved.
Thank you, Marilyn. Is there a second?
Second.
Second.
Thank you, June. There is a motion before us to accept the report. All in favor, please indicate by saying aye.
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 There is a unanimous vote in favor of accepting this report into the record and incorporate. Very much, Chris. We now move on to the agenda item, which is other business. Is there any other business? Hearing none, I would entertain a motion to adjourn this board meeting. Is there a motion to adjourn?
So moved.
Thank you, Randy. Is there a second? Thank you, Michael. All in favor of adjourning this meeting, please signify by saying aye.
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 Aye. Thank you. The motion is accepted unanimously, and this meeting is adjourned. Thank you.
Thank you.